Today on Trial Watch.
I just shot him. I just put the gun up like that and I just shot him.
This battered woman went to prison for fighting back, but she helped change the law forever.
Steve and Risa entered a fertility program to realize their dream of having a baby, but it turned into a legal nightmare.
Our response was incredulity. We just didn't believe that they would say they would keep our frozen embryo.
All this and much more next on Trial Watch. Real people, real trials. Hello, everyone. I'm Rob Weller, and with me, co-anchor and attorney Lisa Specht. Hi, Lisa.
Hi, Rob, and hello to you. Welcome to Trial Watch.
Well, it is the shame of America. Every 20 seconds, a woman is beaten. When she feels she can't escape her abusive relationship, doctors call it the battered woman syndrome. Lawyers use it as a defense when a beaten woman finally strikes back. Now, in the 11 states where the battered woman syndrome cannot be used as a defense, many women have no way to break out from this truly vicious cycle.
They can't get away, either because they don't have financial means, they don't leave the kids, or they've been beaten into submission.
These women are the lucky ones. They did get away and now find help in local support groups for battered women. But for some women, help never came.
He pulled a gun out on me and threatened me with it. He stuck it literally up in my face, told me he was going to kill me. I got a hold of the gun and I told him to stay away from me, and he took another step toward me, and that's when I shot him.
Barbara Miller is now serving 5 to 25 years in the Ohio Reformatory for Women for the 1988 shooting death of her boyfriend. For a year, he regularly threatened to kill her and made her a virtual prisoner in her own home.
If I even talked to anybody else, including my mother on the phone, he couldn't understand that I had to be accountable for my time 24 hours a day. I had no freedom.
Barbara's case is a classic example of what's come to be called the battered woman syndrome, whereby violence and the threat of violence to a victim can eventually lead to violence by the victim.
It is exactly that belief, that feeling that I am never going to be able to leave this situation safely, that sometimes leads victims to act violently as a last desperate act to protect themselves.
I just shot him. I just put the gun up like that and I just shot him.
Take the case of Dianne Hafford. After years of beatings from her live-in boyfriend Cecil, she finally snapped.
And I got the gun up under the bed, and I ran across the bed, and Cecil was coming towards me.
Hafford says she stayed in the abusive relationship because of her children.
I never had a father, so I wanted them to grow up to be with their father. And so I kept going back and thinking that things would get better, that maybe one day that he would really change.
At the time, Ohio law did not allow the battered woman syndrome to be used as evidence. The jury found Hafford guilty.
We feel that the jury got every piece of possible evidence that could be presented in this case and came back with the only verdict that it felt it could. In a sense, they were saying that every life has some worth.
I believe in that battered woman defense. 38 states believe in it. Hopefully there's a lot of women that come forward and tell their side of the story to educate people as to what's going on.
In 1990, Ohio did finally change its laws to allow the battered women syndrome to be used as part of a self-defense or insanity defense. But for Dagmar Celeste, social activist and wife of outgoing Ohio Governor Richard Celeste, the addition of a new law wasn't enough.
I guess the great injustice was that we have been one of the last states to even have a law that permitted the introduction of the syndrome in evidence in trials. So all of these women who are in jail now, who claim that they've been battered, that they committed the crime because they've been abused for years and years and years, are women who never had an opportunity to introduce that evidence in their trial.
Dagmar's husband agreed and used the last few days of his time in office to do something about it. Did the governor give battered women a license to kill? The answer when Trial Watch returns. Well, the nickname of Ohio is the Buckeye State. But for many women, it could have been called the Black Eye State. That's because Ohio was the last major state to allow the battered woman syndrome to be used as a legal defense. Now, not only did Governor Richard Celeste help to change the law, he helped some women for whom the law change came too late. In late December 1990, Governor Richard Celeste brought an early Christmas to 25 battered women doing time in Ohio prisons for killing their batterer. He announced a clemency order, which would let many of them out of prison and allow others early parole.
The question that many of you have asked me along the way is, how could you even consider a case in which a man is killed while he's sound asleep? But I think if you understand what this syndrome is about and realize that to face that person who has done violence to you over and over and over again, threatens violence to you or to your children or to your family over and over and over again, done that violence over and over and over again, there is a kind of helplessness that is experienced in that circumstance.
I feel so great. It seems like it's the best Christmas present there could be.
Beverly Sue Alford was convicted of voluntary manslaughter when she shot her boyfriend after he ordered her to fetch him his gun. Alford claimed he regularly beat her up. Released as part of the former governor's clemency program, she and the others on the list will put in 200 hours of community service talking to other women.
And that's why I'm saying, don't stay there and take the abuse the way I did. Go for help.
Also on the clemency list, Barbara Miller and Dianne Hafford. Happy as these women may be, not everyone thinks the governor's move was the right one. Some prosecutors, like Franklin County's Michael Miller, feel they weren't consulted by the governor, and that some on the list don't really have a battered past. Plus, Miller has a problem with the battered women's defense in general.
I don't doubt for a moment that many of these women have psychological problems caused by their beatings and so forth. But I think if you've got the strength, if you will, to execute somebody in their sleep, then you ought to have the strength to walk away from the problem.
This kind of comment shows how ignorant most of these prosecutors are about the syndrome. It's a little bit like saying that if you're a prisoner of war, you should wait till the guard wakes up before you run.
The statute talks about self-defense, and it talks about a plea of insanity. It doesn't create a carte blanche defense of battered woman syndrome.
While debate about the battered woman syndrome continues, in January of 1991, it was used for the first time successfully in Ohio in the case of Joyce Anaga.
We, the jury, upon the issues joined in this case, do find the defendant, Joyce Anaga, not guilty of the murder of Sunday Anaga.
I just thank God he gave me my life back.
Look at the emotion in that woman. Now, Lisa, why could some of these women not claim self-defense when they were attacked?
Because to claim self-defense, it has to be a threatened attack at the time. You have to be defending yourself. And if you are, that's a complete defense to any murder case.
Mm-hmm. Now, how can one prevent from getting involved in the battered woman syndrome? I mean, what do you do?
Interesting question, Rob. The problem is that when this occurs, most women truly believe they can't escape from an abusive husband or lover. In fact, that woman can escape. She just has to make the effort. You shouldn't be afraid to ask your local women's group, hospital, or even the police for help. Aid is available, but you do have to seek it out.
Quite a story, indeed. Well, just ahead on Trial Watch, Doctors Steve and Risa York spent 3 years and $20,000 trying to conceive a child. Then their fertility specialist did the inconceivable. Embryo held hostage. Next.
One out of every 6 married couples in this country is infertile. And nothing, not money problems, not even infidelity, puts stress on a marriage like the inability to have a baby. That's why so many couples endure the pain, the expense, and the frustration of fertility programs. They'll do just about anything to have their own natural child. But nothing prepared one young couple for the ordeal they had to face. Their struggle to have a baby ended up in federal court.
Steve and Risa York are a very close and loving couple. Steve is a medical doctor, and Risa is a practicing psychologist.
I'm Dr. Steve York. You're listening to KFI AM 640, more stimulating talk radio.
They seem to do everything together. Risa even assists Steve with his medical talk radio program. But what Steve and Risa want most together is to have a baby.
I've always loved children. I love children I see on the street even, and children seem to love me too.
Now I'm starting to realize very thoroughly how much I really want to have a few kids around the house. I like the idea of watching kids grow up. I like the idea of being with them. Yeah, I'll make a good parent.
For most couples, having a child comes naturally. But when you're in the 40s, like the Yorks, the process is less than natural. After Risa discovered one of her fallopian tubes was damaged, they decided to try in vitro fertilization at the Jones Institute for Reproductive Medicine in Norfolk, Virginia, headed by Dr. Howard Jones.
I don't think it was desperate measures to enter that program. I think it was rather just simply seeing what needed to be done and then taking the next logical step. If we couldn't do it one way, we simply had to proceed and try to have a child another way.
In vitro fertilization is a technical miracle. Eggs are removed from a wife during a surgical procedure and joined with the sperm from her husband. Then the fertilized egg or embryo is implanted into the wife's womb. Any remaining embryos may also be frozen for future implants.
I frequently refer to assisted reproduction as the world's most expensive hobby. You can easily cost $10,000 a cycle, and you could do that very easily 3 or 4 times a year. It's an outrageous amount of money.
But the cost, over $30,000, wasn't as outrageous as what happened to their frozen embryo. After several unsuccessful implants at the Jones Institute, when the Yorks moved to California, they wanted to take their embryo with them and try another program, headed by Dr. Richard Mars in Los Angeles, obviously much closer to their home. But Dr. Jones refused to give it to them.
Our response was incredulity. We just didn't believe that they would say they would keep our frozen embryo. The question arose immediately, what claim could they possibly have to it? It's ours.
Dr. Jones, first of all, took it upon himself to assume personal responsibility for the disposition of our embryo when we never asked him to do that. That was our responsibility. We had released him also in writing from any liability whatsoever.
In a bizarre letter to the Yorks, Dr. Jones worried that the frozen embryo could melt or get lost. And he suggested the Yorks might use the embryo as blackmail, sell it, or even destroy it.
We definitely felt that our embryo was being held hostage. There was no question about it. We were told simply that if we did not return to remain as their patients and return to their clinic, then we had no access to our potential child. This is absolutely ridiculous, and they were indeed holding it hostage by any definition of that word.
The Yorks have been free to come and to have the egg transferred in the manner that was originally agreed, so that there's never been any question of the egg being withheld from them in any way.
So, was Howard Jones an embryo terrorist or just a conscientious doctor looking after his patients? His action brought emotional chaos to the Yorks.
He said that we had 3 choices for the fate, as he put it, of our frozen embryo. One was donation to another infertile couple, the second was donation to research, and the third is that they could thaw it, but not allow it to undergo further development, which is tantamount to destroying it. And he was so concerned that we would destroy it, and we wanted to know what's the difference between his flushing it down the drain and ours.
But the Yorks had support in their agonizing quest to get their embryo back.
They're essentially telling them that, yes, you produced this embryo, it's a potential child, but it's ours here in Norfolk. And that's like saying, if I'm an obstetrician and I deliver your baby, well, what makes that baby yours and not mine? I delivered the baby.
No human being has the right to kidnap the child of another human being, even if that child is at the very, very beginning of its existence. The man should be hauled into court and tried for what he did.
The Yorks did haul Dr. Jones into court by filing a lawsuit against him and his institute, but they ran into a problem.
When a couple and a clinic have a dispute over the fate of the embryo, there aren't any laws on the books any place in the United States that specifically protect the couple.
Lori Andrews is the attorney who represented the Yorks' nerve-wracking case against Dr. Jones.
One of the things that was compelling to the judge in the York case was that the Yorks had dropped off their embryo at the clinic expecting to get it back, much as a person would drop their child off at a daycare center and expected to get the child back at the end of the day.
At the last minute, Dr. Jones backed down and agreed to transfer the Yorks' embryo to Dr. Mars. And then for the Yorks came the bitter irony. When their hostage embryo was finally implanted into Risa, she did not become pregnant.
We weren't devastated when it didn't take. We were certainly hoping it would.
Still childless, the Yorks march on, continuing to try to have a child, although some days they feel like giving up.
Going through an assisted reproductive technology program is extremely stressful, financially and emotionally.
My role in this is primarily, besides donating sperm, is to give her a heck of a lot of support, to hold her hand, to let her squeeze me hard when she needs, because it's very physically rough on her.
We just want a baby, and I think it's tolerable.
The Yorks were at the center of one of the first fertility controversies, but it certainly won't be the last. The simple fact is, reproductive technology has far outpaced the law's ability to keep up with it.
Well, when we come back, a legal expert will tell you how the incredible world of high-tech babies affects your life and the lives of your children.
And we're back with Professor Vicky Michel. She is a bioethics expert and teaches law at Loyola University in Los Angeles. Professor Michel, who should really determine the fate of an embryo? Should it be the couple, the courts, the doctor?
Well, I think it should be basically the couple. Certainly for medical decisions, it would be the couple with the advice and help of their physician.
These procedures sound like they're very expensive from the story we just heard, very expensive, and insurance companies don't seem to be paying for this. Do you think they should be required to pay for fertility programs?
Well, I don't think they should be required to pay for in vitro fertilization. I think that infertility is a personal problem and very painful to the people involved, but it's not a social problem so that the law should require payment for it.
But it's so expensive. What is a couple to do if they really want to have a child and they can't afford to go through this kind of process?
Well, I think that given the fact that in vitro fertilization at its best is only 15 to 20% effective, it's hard to say that this is something that we should require anybody to pay for. I think couples really need to think about what alternatives there are, even though I know that many of them feel strongly about having a child that's genetically their own.
Sure. What advice do you have for couples who can't afford to pay $20,000, $30,000 who are going forward with a program like this?
I think they need to think very carefully about all the implications. I think that they need to talk to their physician ahead of time about all the possible problems. And in terms of what might happen to the embryo, perhaps it's helpful for them to have in writing the alternatives and what their choices would be with respect to what would happen to the embryo.
Great. Thank you very much, Professor Michel. Very helpful.
Now we're going to test your understanding of the law. Every day, Lisa is giving you the facts of a thorny legal case. We'll then ask you to be the judge. Match your decision with the courts. Well, we all believe that if we call the 911 emergency number, help will be at our doorstep right away. But when a New York woman called 911, the dispatcher wrote down her address incorrectly. While police searched vainly for her house, the woman was murdered by an intruder. Now here's Lisa with today's Snap Judgment.
Her family tried to sue the county, saying the woman was lulled into a false sense of security, thinking police were on their way. The county said it couldn't be sued because of a legal principle called sovereign immunity. That means cities, states, and counties can't be brought to trial unless they've acted in a grossly negligent manner. What do you think? Did the county's negligence lead to the death of an innocent woman? I'll have the court's decision when Trial Watch continues. Is the county responsible for a woman's murder because the 911 dispatcher wrote down her address wrong? The court said yes. The judges ruled that the county didn't have to set up the emergency service, but once it did, they had to run it properly. The woman in this case relied on the dispatcher's assurance that police were on their way, so she didn't run from the house or even try to call a neighbor. Because the 911 service was grossly negligent, the county could be brought to trial.
All right, now here's a story of how the police responded not just efficiently, but heroically, and still wound up in court. Officers Devin Chase and Jerry Wallace were cruising through Torrance, California. They saw 24-year-old Margaret Parkinson unloading a bicycle from a car which was double parked. Knowing that that was dangerous, they made a U-turn to warn the girl to move closer to the curb. At that very moment, a drunk driver smashed into Margaret. Her leg was bleeding badly and she had no pulse. Thinking fast, Officer Chase improvised a tourniquet with a knife and a piece of rope. Then he administered CPR while his partner drove to the hospital. Well, Margaret survived and the policemen were awarded the Medal of Valor. Margaret's father said he was terribly grateful to Jerry Chase, who undoubtedly saved his daughter's life. Then he turned around and sued the policeman and the city for $6 million, claiming Officer Chase should have stopped in the middle of the street to warn Margaret that she was in danger, Lisa.
We're going to keep an eye on this case, and I don't know about you, Rob, but I'd feel very comfortable with this kind of police officer in case I had an emergency.
Oh, he did a great job, didn't he?
He really seemed to. That's it for today.
Join us again tomorrow for Trial Watch. Real people, real trials.